Hello, good night. This is U.S. Immigration Attorney Sharifa Tharb. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. Today, I want to cover a very important topic. It's relevant right now because, as you can see, if you look in the news, you see all the chaos. They have diverted even law enforcement. FBI agents, a quarter of FBI agents are now doing ICE's job. They are a part of immigration enforcement. So you have portions of immigration, of law enforcement doing immigration work. And because of that, we are seeing activity on a level that we've never seen before. And so it's important, while I want to stress that there are always legal processes, and here at the law office, we see hope because our clients continue to get protection and they continue to go through a regular process. They continue to go to their biometrics appointments. They continue to proceed in their process. So the process continues. But it's important more than ever to also evaluate if you are detained by ICE and they actually do take you. Now, I do talk about your rights, the right to remain silent when you are stopped, to make sure that you exercise that right. Yes, as an immigrant, you have constitutional rights as well. If you're here on US soil, you have constitutional rights. Make sure that you have your identification. If you don't have valid identification, make sure that you understand that you don't have to talk about your place of birth. While you may have to provide them your name, you don't have to tell them anything about your immigration status, because you can exercise the right to remain silent. No, in cases like, a lot of people will be like, oh, why are you saying that? That's not going to stop them from being detained. And yeah, that's true. But you should not be blabbering off to somebody who is not your friend and who's going to use the information that they get from you to quickly deport you. And you're actually putting yourself in a position, in a more advantageous position, because you can develop your defense without them using the information you provide for them to deport you quickly. Because keep in mind, by talking, just by freely giving information to the officers, they can quickly determine whether they're going to put you on a plane and send you out of the country before you have a chance to talk to a lawyer or before you have a chance to exercise your constitutional rights. So you protect yourself by remaining silent until you talk to your attorney. The other thing is, you're going to tell the officers, I want to exercise my right to remain silent and I want to talk to my attorney. This is where it's so important to have a plan, build relationships with an attorney. Make sure, and the way that you can build relationships with an attorney is by starting with an appointment to understand your legal rights here in the United States, whether you have legal options. And if you end up in a situation where you are detained, you can quickly call that lawyer to get assistance. And for example, with us, we'd already have your file, we'll already know your history, and that can enable us to jump into action faster than in a situation where we're starting from scratch. Keep in mind, we're taking calls, where we've expanded our practice to make sure we have a robust removal defense process in place at this firm, because we want to be able to help people quickly and when they need it. And it's needed more than ever. So, but that is not what I'm here to talk about. And I have multiple videos on how to exercise your rights, why you should exercise your rights, plans that you should come up with in the case of an emergency. But what I want to focus on is, okay, you're detained and you're taken into ICE. What happens from there? Now, assuming that you have maintained the right to remain silent, you don't talk about your place of birth, you don't talk about your immigration status, you are going to use that phone call to either call a family member, a contact that you have given an emergency plan to, that they will contact the attorney very quickly, or you're going to have the number of your attorney. And that really should be one of the first calls you make, is to your attorney. The reason why I say this is because if they plan to put you through an expedited removal, that means they plan to just put you on a plane and ship you out without due process. That attorney can jump in quickly to be able to file an emergency stay of removal to be able to get you to stay here at least for some form of due process. So you want to make sure that one of the first people you're talking to is the attorney. So have that number ready, or have an emergency plan where you have a contact that has that attorney's number to call the attorney ASAP. Here at the law firm, we do run our phone lines 24/7 to be able to take those calls and then be able to jump into action. Now, what happens? What options do you have? Can you just be removed? So the other thing to consider is if you've been here for less than 2 years, they may go ahead and initiate expedited removal. So it's very important that you preserve documentation and evidence showing that you have been here for more than 2 years, that your attorney can use to defend against any kind of expedited removal that might be brought against you. So make sure that in your packet, in that place that you hold all your important documents, you're going to have maybe past driver's license that you've been issued in the US, maybe tax returns that you filed, lease agreements that you have, any bills that you've paid in the past couple of years. Make sure that if you have children, make sure you have copies of their birth certificates showing that you've had children over the years in the United States. If you own property, if you own a car, if you have car registrations, save those registrations showing that you've been here for more than 2 years. Now, one other thing to take note of is, what if you have been here for less than 2 years? What then? Right? Because they could subject you to expedited removal. What then? Well, in that case, if you are here, and in many cases you are here because you fear going back to your country, and if that's the case, then you need to state very clearly, especially if they're about to put you on a plane, that you fear going back to your country because you fear being targeted and you need a credible, fair interview. At that point, they're going to put you through they are required under the law to first put you through a credible, fair interview to determine whether you qualify for possible asylum, withholding of removal, or convention against torture. Right. And of course, having your attorney there is going to make sure that you can approach this strategically and properly, because I know these are complicated terms that I'm throwing out there, but I want you to at least know the basics to understand that there are options available. Now, if you are detained and you're trying to figure out next steps, what usually happens is when our clients are detained, we jump into action. And I know that sometimes it feels like time is just standing still because it is a process. But we immediately establish representation with immigration. So we send them a G-28 to show that we are now representing our client who's detained. And then we establish contact with our client at the same time that we are talking to a point person that's going to help us to gather the documentation that we need to represent our client. We are going to determine whether bond is going to be possible here and whether it's feasible. Now, bond is still possible in some circumstances. Right now, we do have situations where they have found that anybody who entered the country without permission and they're detained are subject to mandatory detention without bond. That that is happening is some individuals are suing in federal court to get habeas corpus. So that's also another approach that you have to think about, another possibility, because federal court can always decide differently. But in the case that you entered with permission, you entered with a visa, maybe you overstayed, maybe the visa was revoked, in that case, you can still possibly qualify for bond. So don't think that detention means you can't get out. And so we determine, okay, is bond possible? That's one of the first things we look at. How does one qualify for bond? So you do have to show the court. So what you do, ICE does have the authority to do bond. Of course, that is going to be on a very stingy basis right now. So the next option is court. We file a bond request in court, and at that point they quickly, so our experience is the court quickly schedules a bond hearing within 10 days of the request. So once we get established, we establish contact with the family at our client who is detained and their family or friends. That's a point person. We start to look at proving their ties to the community, that they are not going to be a flight risk or unlikely to be a flight risk and unlikely to be a danger to the public. So you may have maybe minor offenses, maybe traffic offenses. You may not have anything in your background at all. Right now, a large percentage of immigrants are being detained with no criminal history. So at that point, we present this to the court, and then the judge would then decide. There is a bond, so the judge can, the minimum amount is $1,500, and it can go up as high as $8,000. So you also have to think about that as well. The fact that yes, there could be bond, but it can range anywhere from $1,500 to $8,000 that you or your family would have to post before you're able to be released. But it means that once you're released, you can focus fully on your full defense, because it's not over. You are then bonded out, but now you have to focus on your defense. The court is going to say you can continue to be out as long as you show up to the court hearings that we schedule. There are two court hearings that, at minimum of two court hearings that you have to plan for. The first is a master calendar hearing. And that is a very brief hearing. It can range anywhere from 5 minutes to 15 minutes. Most of the time is spent waiting to talk to the judge. The judge is going to look at the notice to appear, read it out, and it's going to ask you, how do you answer to the charges on this notice to appear, the immigration charges. And you have to then at that point present the defenses. So by that point, we understand our client's circumstances. We've spoken to our client. We've spoken to close family members that understand what our client is going through. And we have established what our client qualifies for to defend against removal. And we state it there. Then the judge will give us further instructions about when to file pleadings, when to file motions, when to file briefs in regards to the defense that we're going to file on behalf of our client. And then maybe when you're detained, it can be within 6 months. When you're not detained, it can be a 6 months to a year out that they will schedule what's called an individual hearing. And sometimes it depends on the complexity of the case. Because, for example, we do have a client who's a minor, and we have explained that our client qualifies for relief outside of deportation, outside of the court. And so the judge has said, okay, well, we're going to put a hold on the proceedings to give you an opportunity to pursue that relief outside of the court, and we'll continue to do a status check. So the court will check in to see how's that going, what's going on with that, to determine whether they're going to move forward with an individual hearing. So sometimes you may have multiple hearings that are more like check-ins before you get to the individual hearing. The individual hearing is now is sort of the final trial. That's where the attorney, so where we present the defenses of our client, and then the government attorney will come in and they will either rebut it, they will oppose in circumstances where we are going as far as the individual hearing, and the judge will then decide at the end of the day if the client qualifies for the relief that we're applying for. What kinds of relief? So there's cancellation of removal. Some people end up detained and walk out of the court with their green card, right? So that's cancellation of removal for people that have been here for 10 years, for example. They have good moral character. That could be a good option. And of course, you have to show that you have a US citizen or permanent resident relatives. Then you have others, you do still have asylum. And it's important, though, to make sure that you understand asylum comes with deadlines. So if you are here within a year of, it's still within a year of your entry, you need to make sure you get in touch with us to talk about why you fear going back to your home country and whether asylum works for you. Because asylum is for people who have been targeted in their country or fear being targeted because they're maybe because of certain circumstances, their religion, their identity, their particular social group, their political opinion, their religion, their ethnicity, their nationality. These, if you have any kind of fear because you have a belief system that your country your country doesn't accept, that or you have an identity that your country doesn't accept, maybe it's controversial, and as a result of that you're threatened with violence, that could be an option for you. But there is a deadline that can make it even harder to get it, even if you are in immigration court seeking asylum. So this is where I say establish your legal, what do you qualify for legally that could keep you out of immigration court. But in a worst case scenario where you are detained, you are able to still present this to the court, and then the court can decide whether they are going to give you the opportunity to pursue that relief outside of court. So the point of this is to say, guys, that even in the worst case scenario, you're detained, there are ways, there are options. But the key is to make sure that you explore your options beforehand in case there's something you can pursue before it gets that bad. But that also enables you to build a relationship with the attorney that you can call in the case that something happens. That is what we do keep our clients' file. We keep notes that we've taken. It's all confidential, but we keep it. So if the client calls back, we have the information to be able to help our client very quickly, to get them onboarded and get started very quickly. So make sure that you are thinking about this. I know it's nobody wants to think about this possibility. And this is where I say, if you don't want this to be a possibility, make sure you're being proactive and looking at options outside of immigration court, because there are options. And I see that every day. And I want to scream on the mountaintop that there still are legal options, despite the chaos that we're seeing on the news. Here at the office, we are seeing our clients' processes move forward. All right. All right. So now I'm opening up the floor for questions. So put your questions in the comments and I will answer. Can you go to Jamaica with a green card? Or you have to, have a passport, 10-year green card? You can go if you have a green card, you can go. Just make sure you understand what's in your background. Make sure there are no red flags that will cause them to stop you or give you problems. How can I reach you personally? Now, um, the way you're going to reach me is through the law firm. We have attorneys, we have an entire legal team, and that is what makes our firm successful. Is not only, of course, with my leadership, my vision, but what makes my vision come to life to be able to change lives is my legal team that's behind me. And so, if when you give us a call, schedule with our attorneys here at ST Law Office, because they know what I know. We work closer together to make this possible. And you are hurting yourself if you are not taking action because you just can't talk to me personally, because that's not how it works. The way that we get the wheel turning for our clients is through our legal processes within the firm. So take note of that and give us a call. Why? How do you think our clients are winning? Our clients are winning because they make the move, they give us a call, and they get started with us. They get started with us here at the firm because we're a team of attorneys, paralegals, legal assistants, and a team that answers the calls to make sure that people are getting help quickly and efficiently. So give us a call. That's what makes this firm great. Trust me, if I was just sitting in this office by myself, it would not work, right? It's a team effort. And that's what makes me grateful that I get to do this. I had a 1 year visa that expired in 2019. I was married to a US citizen for 2 years and divorced in July 7th. How much will the VAWA cost, and how long will I receive work permit and green card? So give us a call, talk to us. Once you're divorced, the clock is ticking. You have 2 years to apply for this. And trust me, you don't want time to go on you, or you don't want to sit there, be a sitting duck, and keep yourself at risk. Call us, talk to us. It really depends on your case, your facts, because that's what we do. We listen to your facts and then we get started based on the facts. We can give you the quote based on your facts. Now, how long does it take to get the work permit? 6 to 12 months is a timeline to get the work permit after filing. And then the green card comes at about the 3 year mark. And I want people to understand it's important, especially now, to avoid being short sighted. No, nothing in the immigration process comes overnight. But what really determines success in this immigration process is getting started. And so if you delay because, oh, that takes too long, nothing else is going to move faster right now in immigration, especially if this is the only thing you qualify for and you're not making a move. The more you delay, the more you're hurting yourself and the more you're delaying getting to the solution. My clients who got these work permits, when they get it, they don't complain and say, oh my gosh, this took so long. They are so happy because it was worth making the move and getting started, because just with the blink of an eye, they got protection and they're okay, right? So give us a call. We would love to talk to you to figure out a solution ASAP. All right. Hi there on TikTok. Thanks so much for the love. I appreciate this and I appreciate the engagement on YouTube, Facebook, TikTok, Instagram. The reason being, your engagement is still helping people to be able to see this information and to be empowered. Because while a lot of scary things are going on, I'm here to bring hope to you, to let you know that there are legal processes that are still going that can help to give people protection and still the hope to move forward and gain stability and achieve your dreams here, whatever that is in the US. All right, so TikTok, thanks for the follow. I appreciate it. Does interim parole allow me to get married and adjust my status? So I'm not sure what you mean by interim parole. If you're paroled into the United States, it has to be a special type of parole, a humanitarian type of parole, then you can adjust status in the US based on that parole. But this is where it's important to give us a call, talk to us about your situation, and let's confirm you qualify and get started the right way. Can an CHNV parolee with pending TPS apply for a green card through U.S. citizen husband? So yes, that type of parole can still qualify one to adjust status in the U.S. through a U.S. citizen spouse. As long as you are given parole with a legal entry, then you can qualify. You may qualify. Now, keep in mind, I'm not your attorney. Can't give you personalized legal advice. But that type of parole with that type of parole, you would be able to adjust status. Is it safe to travel with advanced parole after removal proceedings dismissed through PD, which is prosecutorial discretion? Great question. That definitely puts you at a high risk. Anything to do with, first of all, they are reopening cases that were dismissed or terminated. So in the case that they see this on your record or they try to reopen the case and you don't know and then you travel, this can be a disaster. Now, not to say it can't happen. It's always good to have the travel document or the advance parole, but please make sure that you understand all the risk involved, the pros and the cons of the situation, and that you make a decision based on that. Is it worth the risk at this point? Can I travel on my 2-year green card internationally? Yes, green card holders can travel. But where we are seeing green card holders being detained is a past criminal history that renders them deportable. So, for example, like drug trafficking or any kind of offense that renders them deportable. Where you went from 2-year to 10-year and then maybe you never applied for the 10-year. So you had 2-year, but never went for the 10-year. So you're sitting there with a status that seemingly expired, but there is a way to fix that. So if you're in that situation, give us a call. If you were outside of the United States for a long time, over 6 months, then they can hold that against you as well and say that that is evidence that you've abandoned your residency. So beware when you're coming in, you have to make sure that you can explain why that was a lengthy stay for you. For N400, can military personnel get their case expedited? It depends on what your circumstances are. For example, are you going to be deployed? If you're going to be deployed, then that could possibly be a basis to expedite. So we have successfully gotten a case expedited based on our client being deployed. Let's see, can I travel? So I answered that. After you get prima facie through VAWA, how long it takes for a worker authorization? So the prima facie will be issued regardless of they don't make timelines based on issuance of the prima facie, but what I can say is 6 to 12 months after you filed your VAWA. Need to file N400, married US citizen, 5, had illegal dumping a year ago, had a charge of illegal dumping a year ago, dismissed. Now, what I would say, guys, is it's still very possible for you to get citizenship, but you have to do it properly. If you approach this citizenship application wrong, in the wrong way, or you don't address this charge, sufficiently, it can still come back to get you a denial because they have stated that they can even deny for non-criminal. So be careful. We can help with that for sure. But we need to understand, we need to get to know you, figure it out, and then know exactly what to put in the citizenship application. Would I add WIC to the I-912 or only SNAP? So when it comes to the specifics in the form, I can't answer that. Is it safe to travel with advanced parole after removal proceedings dismissed? You'd be at a very high risk. So you definitely need to seek legal advice and, make sure you're represented. Talk to your attorney. All right, so now I'm on YouTube and Facebook. Two teenagers that was sent back to Jamaica by their father and documents taken. What can be done? So that sounds like a custody issue. That's very complicated. That sounds like a family issue, especially if the two teenagers are U.S. citizens. Can I be deported if MPIP is which is military parole in place, is being processed? I applied for re-parole under MPIP. MPIP, which is military parole in place, gives you protection. So I don't know if it's expired yet, but that is giving you protection. Good evening, Attorney Tharp. Hi. What happens when you have about two misrepresentations? How do you go about it, and what are the consequences? Give us a call. That can be very serious. And if you don't approach it properly, you can face permanent bars. Now, we have gotten our clients forgiveness for this exact violations, but it depends on what you qualify for, what are you applying for, who are you related to be able to determine what the best course of action moving forward is. But what I can say to everybody here is whether you enter the country without permission, you have things like misrepresentation or criminal charges, there are ways to still fix that for you to get your papers. Yes, it's possible, it's under the law, and that's why it's there. But you have to give us a call. Let's talk and see what you qualify for to be able to strategize and move forward. Our phone line is 24/7. You'll see the phone number going along in the ticker at the bottom of the screen. And if on TikTok, you go to the top of the comment section, you'll see my number there. Give us a call. Oh, the team is here waiting for your call. The team and I work closely. We have multiple attorneys here that win cases. And so definitely give us a call, schedule an appointment with one of our attorneys so we can get to work. Did you know anyone in your office approved for VAWA within 18 months? Um, no. So right now the processing time is over 3 years, a little over 3 years. What our clients do get though is our work permits and protection first. And that is crucial right now, especially for working families, working individuals that still need to move forward with their lives despite everything going on. All right. And so that's going to be it for me tonight. Given the current political climate, can I travel to Jamaica on AP that I got from my pending VAWA case? You should really make sure, for example, for our clients, we are very conservative and we let them know if you travel, you have to bear that risk that when you're coming back in, you could be detained or denied entry. But it really depends on what is worth it for you. I don't know what your circumstances are, but is it worth it? I would say the risk is high, and AP does not give you a right of reentry. So if you're coming in, something goes wrong, it can turn ugly. Okay, so you say I can go to Jamaica with just a green card, no passport, and come back? No. And this is why I say I am not giving specific legal advice. Please don't go do anything major like travel, get married, get divorced, do anything. Even don't go apply for your immigration. based on a life, right? Because I'm not your attorney, I don't know your specific facts, and I don't want anybody to go make mistakes. I give general information though that can empower you to reach out for the help you need. Now, when it comes to traveling, generally, you do need a passport to come back into the country. You can't just leave with a green card and come back with no passport. You still need to have your Jamaican passport along with your green card. Um, Are ICE hanging around at domestic TSA points? I have permanent resident card and real ID. If you're a permanent resident, you don't necessarily have to worry about traveling unless there's something in your background that is giving you concern. And if that's the case, you need to be proactive and get legal advice. I would say this: ICE, they're hanging out with police, waiting for traffic stops. They're going into schools, they're going into courthouses, they're going into hospitals. I sure as well know that they're hanging around the TSA area waiting to pick up some people. So, absolutely, they're there, right? If they can be in all these areas that you think have some kind of protection or insulation, they can go into churches, they can go into these places and pick people up. They can do it at the airport. That's a really nice spot for them to take people up, pick people up. So yeah, interview for a marriage-based green card, a good sign. They're doing interviews now more than ever, so they're not waiving interviews for marriage-based interviews. What I would say is it a good sign? Make it a good sign. It's an opportunity. Don't go in there feeling like doom and gloom. You need to make it the opportunity to prove to them that you have a solid marriage. And so when you go into these situations, it's an opportunity to get your approval. So make sure you know what to do going in. Are you seeing a lot of extensions on removal of conditions? So that continues as normally. Now the processing time is long. It's average time is 4 years. So it's still long, it's still taking time, but yes, those continue. And do not, if you have going from a 2 year to a 10 year, you should not fear doing that. You should fear not doing that and getting picked up. You must make sure that you apply for your removal of conditions when you are supposed to. And if you're divorced, if you're separated from your spouse, if they're mistreating you, if you're separated, give us a call. You can still apply with or without that spouse, but we have to know your circumstances to know what waiver to apply for. But do it timely. I find that the most complicated situations is where those people do not apply. They give up, they think they don't have the ability to apply for the 10 year, going from the 2 year, and get into more problems. Because if you don't apply, you are going to be sent a notice to appear and be sent to immigration court. And if you don't go to court, you're going to get a deportation order. So you must make sure. Now, if you have been referred to immigration court going from a 2 year to a 10 year, know this: that is a second chance. It's just before a judge, but it's a second chance to show a judge that you do qualify for the 10 year. So do not look at it as no hope, right? Court is, even though it's stressful, court gets stressful because it involves detained immigrants. Keep in mind that court is that opportunity to pursue relief that can get you out of court and get you your papers still. All right. So thanks everybody for your time tonight. I am going to work to get to be back tomorrow. So what I say is I am on different times of the day. So what you can do is follow me, like, subscribe, share. This is what helps me to go on your timeline when I go live, so you can get notification, but it also helps others to see me as well. Thanks for the love. Thank you for the love on Instagram. That gives me a lot of energy, guys, to do continue to do positive things and continue to empower immigrants. So thank you for the love. I feel it. And you're doing good by just doing that. All right. Have a good night. I'll see you tomorrow. Bye bye. Thank you.